Yeah, but do I have to press the icon which says start sharing, or or okay, okay.
Welcome, sir.
Thank you, thank you. Shall I start?
Yes, sir.
Okay. First of all, let me thank AK Law Chambers and everyone involved in it for giving me this opportunity to share a few thoughts on the aspects of the IBC. Now, the subject is controversial aspects on the IBC in India, but a large part of my presentation is going to be topical. So please don't expect that every statement I'm making is going to be a controversial statement, or I'm only going to deal with controversial subjects. So what I will do is I will deal with some issues which, controversial or not, are ambiguous. I will also deal with certain topical subjects, and at the end of it, we could have an open discussion. I'm not so presumptuous to call it a question and answer session because a lot of questions which we may say may not have answers. So I would, if this webinar permits it, like to have a discussion at the end of it so that each of you can share your thoughts and we could possibly see if we can mutually find an answer to some of the ticklish issues in the IBC. Now, to start with, let's go back to the beginning of the IBC. Shiva, if you could put up the first slide.
Yes, I will just put it up. Yes, sir.
First slide, the one before this. Sorry, the one even before this. Yeah, this. So this is the basic background and introduction to the IBC, which you're all aware of, I'm sure. I only want to bring out one aspect to it. It's something that I've wondered for some time, but there is an answer. Why is it called the Insolvency and Bankruptcy Code? Why not just the Insolvency Code or the Bankruptcy Code? And what is the purpose behind it? Going deeper, you will find that insofar corporates are concerned, which is going to be the primary topic of our discussion today, the process is insolvency, an insolvency resolution process, and either the success of it or on the failure, it goes into liquidation. Bankruptcy is in the context more of individuals and partnership firms, because there also there's a process of insolvency and bankruptcy. So that's process because this act is covering both such aspects. It's probably called the IBC. But insofar as today's discussion is concerned, since the individual and partnership portions have not been notified except to the limited extent of corporate guarantors, or rather the guarantors of corporate debtors, we will not be going into the bankruptcy aspect at all today. Now, just to go back a little bit, and the reason why all of this came about was we had two separate enactments. We had the SICA, the Sikh Industrial Companies Act, and we had the Companies Act 1956, which got subsumed by the Companies Act 2013. There were two separate enactments, and the process was that industrial companies which faced a certain negative net growth and loss of assets, etc., would mandatorily have to make a reference to the BIFR, and there was a process by which the BIFR would undertake all these activities. They would appoint an operating agency. They would then go into the operating agency would formulate a rehabilitation plan. If the rehabilitation plan met with the approval of the BIFR and of the creditors, it would come into force. Else, what the BFR could do, and it didn't have the power to liquidate a company. All it could do was to recommend to the High Court that this company be wound up or liquidated. Now, you had just one BFR in Delhi, which was considering the revival and rehabilitation of companies all over India. And of course, you had one AIFR, which was also in Delhi. So we can understand, undoubtedly, there would be inordinate delays in this whole process. Now, let's assume you come to a stage where the BFR recommends that the company be wound up. What happens thereafter is that it gets referred to the High Court. And the High Court would have to take it up and hear it as if it were a winding up petition, and whether it was just and equitable that this company be wound up. It doesn't mean that merely because the BFR recommended it, the High Court was bound to accept it. The High Court would independently exercise its own discretion to consider whether actually this company ought to have been wound up or not. So you had two stages of delay, one at the stage of BFR and the other at the stage of the High Court. Because High Courts also had so many other pending matters before it, as you mentioned, to keep it. So the whole process of the IBC, and just going back a little bit to give you a background before we get into the various aspects of it, was to reduce the time, to incorporate both these activities into one code before one tribunal, and fix a specific time frame within which each of these activities should happen. If it weren't, then the winding up would happen before the tribunal itself at the end of a specified time limit. So the idea was, it was not to liquidate companies. The idea was to try and revive and rehabilitate companies, because the whole purpose of this was to find a resolution plan which was acceptable to the creditors and to the company, which could work, and therefore this whole process could happen. So the idea was, come up with a resolution plan, get the creditors to approve the resolution plan, and put it into place. If that was not possible at all, then what would follow would be the automatic liquidation. Within a specified time frame, there was no resolution plan in place, or the resolution plan did not meet with the approval of the creditors, what would follow is liquidation, and within a specific time frame. This is a basis on which the code was enacted. It has certainly served its purpose to a large extent, because things have got expedited. Of course, it's not always possible to do things within specified time limits as set out in the code, but certainly the speed at which matters are happening is much better than the position it used to be. Now, Shiva, can you go to the second slide? The
Yes.
second, third slides, I'll flip through very quickly. These are only the processes. I'm just giving you a flow chart of the processes involved up to the submission and approval or rejection of the resolution plans, just to understand the basic flow chart. I won't spend any time on this. If anybody needs to come back to this later, we'll always come back to it. The third slide is on the waterfall mechanism. This is a new waterfall mechanism under which whatever's realized is distributed amongst the various stakeholders in the company. This again we skip over, because again this is a waterfall mechanism for the various processes. Let's now take a specific subject, and from here onwards, let's do specific subjects for which there has been a little bit of back and forth, and ultimately the laws got settled. The first of which is on the question of limitation. Please go to the next slide. The first issue that arises is on the application of the Limitation Act to proceedings before the IBC. And this is where there has been a lot of back and forth by various fora. And ultimately, it has got settled now, but we need to understand how this happened, because there is still one or two issues which are open on this. When the Companies Act 2013 was enacted, there was a specific provision included saying that the Limitation Act would apply to proceedings, to legal proceedings commenced under the Companies Act. However, when the IBC came into force, there was no such provision. For whatever reason, they chose not to include a provision making the Limitation Act applicable to the proceedings before the NCLT. So the issues that came up were whether you could commence a proceeding which was hopelessly barred by limitation under the IBC because there was no limitation act made applicable to it, and neither was there any inherent provision in the act providing for any kind of a limitation to commence except a monetary value on the kind of claim that could be made. This is the first judgment, or one of the earliest judgments on this aspect, was in Neelkant Township and Construction Private Limited. It is a 2017 order of the Mumbai bench of the NCLT, which held that because of the absence of a specific provision in the IBC, the Limitation Act would not apply to proceedings before the NCLT. This matter was taken up in appeal, and the NCLAT also confirmed the fact that the Limitation Act would not per se apply to proceedings under the IBC. A further appeal was filed before the Supreme Court, at which case the matter being directly issued before the Supreme Court ought to have been settled by the Supreme Court. However, what the Supreme Court did was it set aside the order of the NCLAT and consequently of the NCLT, and held that they're leaving the question of applicability of the Limitation Act to IBC proceedings open. So they left it open without deciding it either way. So therefore, in the light of this, one had only orders to the effect that the Limitation Act didn't apply, and you had the order of the Supreme Court leaving open the question. So therefore, the matter went back, and the whole process of applicability or otherwise of the Limitation Act again underwent a lot of churn before various tribunals of the NCLT. In Machar Polymer, the NCLT Mumbai again held that since Limitation Act, and this is where they brought in that distinction, they said the Limitation Act is applicable to proceedings before the Companies Act. However, IBC Limitation Act was applicable to proceedings on the Companies Act. IBC being current law which governed voluntary and involuntarily winding up proceedings. The logic of the Companies Act would apply because this is actually a successor to the Companies Act. The provision of the Companies Act relating to winding up, which actually never came into force, because what happened was after the 1956 Act, before the 2013 Act could come into force, IBC came into force. Those provisions never took place. But what the NCLT held was, since this is a successor litigation to that, the same principle should apply. However, the NCLAT was of the view that the Limitation Act did not apply. And they also added a further rider to it, saying that the right to institute claims under the IBC arose only by 1st of December 2016. And therefore, since the very Act itself came into force in 2016, anything filed 3 years after the coming into force of that of the code could not be barred by limitation. Now the matter went again. The NCLAT had again to consider this aspect in speculum plastics and in a batch of matters relating to the BK Educational Services. The question that specifically arose for the consideration of the NCLAT there was whether the Limitation Act applied and whether a claim which was hopelessly barred by limitation could be brought in merely because the code got notified several years later. Could you resurrect something which was dead long time back merely because the IBC was enacted thereafter? The NCLAT reiterated the Limitation Act would not apply. However, added a rider to this order to the effect that if a claim was severely barred by laches, if a party was not vigilant in commencing proceedings, and if he was guilty of laches, of having sat over his right for several years, then that would be a defense to the respondent. It's not that it is automatically thrown out. If such a defense is taken by a respondent and based on evidence adduced in support of such laches, that would be enough to reject this claim. So therefore, one more limb was added. Limitation Act did not apply, but laches would make the proceedings ineligible, is what is held in BK Educational Services. Now, at this stage, the code was amended by the Second Amendment Act of 2018, in terms of which Section 238 was introduced, which clearly said that Limitation Act would apply to proceedings before the NCLAT, DRT, and DRE. So therefore, to avoid this controversy, the code was amended, and 238A was inserted to make the Limitation Act specifically applicable to proceedings before the NCLT and NCLAT in this instance of the considered. Now, one would think that with this enactment, the controversy would come to an end. Actually, it did not. Because what really happened was, the question was whether 238A was prospective or retrospective, because it was a substantive amendment made to the code. Therefore, the argument taken was it could not apply to any proceedings. It could only apply to proceedings which were instituted after the amendment came into force. Therefore, BK Educational Services by this time was pending in the Supreme Court. The Supreme Court passed an order. Please go to the next slide, Asha.
Yes.
Now, in this, the Supreme Court, by its order dated 11/10/2018, in the BK Education Services batch, was considering this issue, whether this amendment to the Limitation Act was prospective or not. Now, what the Supreme Court held, and with due respect, I must say very rightly so, was that it was never the intent of the legislature to resuscitate dead claims. By enacting the IBC, it didn't mean that dead claims could be again reagitated. Section 238A, therefore, they held was procedural and clarificatory in nature, and therefore would have retrospective effect. They've gone quite some distance, because once you introduce a provision like this, the general thinking was, and this is what certain NCLTs also held in the meanwhile, that you have introduced now Limitation Act as by way of an amendment. Obviously, the amendment will take force only from the date on which it's come into force. However, the Supreme Court, in this judgment, as you pointed out, held that it was not, this is not something new which has come up. It was always the intent that time-barred claims would not be agitated. And you have provisions, the Limitation Act, 29A, etc., which point out that if there is no specific exclusion, etc., the Limitation Act should apply to all legal proceedings. So what they pointed out was this actually clarifies and only sets at doubt the position of whether the Limitation Act would be applicable or not. Since it's procedural and clarificatory, it would have a retrospective effect and would apply even to pending proceedings. So this, I think, was a significant judgment in deciding whether the Limitation Act, the applicability of the limitation. Two things happened. It set aside, which set at not depending controversy, or you may call it the raging controversy. The first was that the introduction of 238A. The second was the judgment in BK Education of the Supreme Court that said that this is retrospective and not prospective, and therefore would apply to all pending proceedings. This is obviously so, because otherwise we'll have two sets of proceedings. One so time-barred proceeding which can be pursued before the NCLT. And number two is proceeding is started after the amendment, whereby the Limitation Act will apply. So all these controversies were set at rest, but still two positions remain, because the question is, what is the time taken? What is the start point? What is the end point for limitation? Which day would it start, and how would limitation count for the purpose of adjudication? Now, there were several judgments. I have referred to it here. I'm not going to trouble you with taking you through the judgments. The thinking was that this 3 years, yes, Limitation Act applies. Yes, it is prospective in nature. But while considering whether a particular case is time barred or not, it would need to be considered whether it was filed within 3 years of the coming into force of the IBC or not. Because you could not go to NCLT under the IBC till the Act actually came into force, or the code came into force. Therefore, the date when the code came into force was the trigger for limitation and not any other date. This again seemed to go contrary to whatever the Supreme Court has said. But nevertheless, this again created further controversy. You have various judgments. And ultimately, please go to the next slide, Shiva. In Sagar Sharma's case, Sagar Sharma versus Phoenix ARC, it's an order dated 30/9/2019. The Apex Court came down very heavily on NCLT, which were taking various stands regarding the commencement of limitation. They said that in terms of Article 141, it is mandated that the Supreme Court's judgment be followed not only in letter but in letter and spirit. The date coming into force of the IBC cannot and does not form a trigger for the point of limitation of application, and Article 137 would apply, which means the cause of action would be the same as if you were to file a suit or a winding up petition and any of those proceedings. This is not a matter which forms a specific article under the Limitation Act. Consequently, the residuary article, which is 137, would apply, and it should be filed on the date when it ought to have been filed, and cause of action started within 3 years of that date. The coming to force of the IBC is not relevant insofar as this. So this finally settled ultimately the controversy and the issues which related to the applicability of the law of limitation insofar as the IBC proceedings were concerned. There's just one other issue of limitation which I think I should make a mention. This is the latest judgment of it's a very unusual judgment of the NCLT, where 5 members sat and decided this. NCLAT, I'm sorry. 5 members in Padmakar versus SF. This is not, I've not seen the report, it's not come out yet, but this is I'm picking this up from the notes which have been shared with me. I don't think it's been posted on the web yet. The question that arose in this case was whether an acknowledgement of a balance sheet would constitute an acknowledgement of liability in terms of Section 18 of the Limitation Act. Now, there is a line of cases which we have seen both in the context of suits as well as winding up proceedings, which have all held that a balance sheet acknowledgement is an acknowledgement. It satisfies all the requirements of Section 18 of the Limitation Act. However, the NCLAT in this judgment held that the filing of a balance sheet is a mandatory requirement in terms of the Companies Act. Since it's a mandatory requirement, and this is a majority, the minority has taken the view that it's not the case, and it probably appears to be the right view, the minority thing, not the majority. The majority holds, and it's a very, if I may see, it's a very unusual reasoning. It goes contrary to the well-known accepted provisions on this. They have said that since the balance sheet is a mandatory filing under the Companies Act, the filing of such balance sheet or the reflection of any amount in such balance sheet cannot be treated as an acknowledgement of liability under Section 18 of the Companies Act. of the limitation. We need to see the full judgment to understand how this has been reasoned out. But if the notes are anything to go by, it appears to be on a slightly incorrect premise, with due respect, if I may say so, because while the filing of a balance sheet is a mandatory requirement, the contents of the balance sheet are not mandatory. I mean, it does not mean that you have to acknowledge a liability in the balance sheet. There's no such requirement. If there is something due, it has to be acknowledged in the balance sheet. If you find it is not due, then no such acknowledgement follows. Or, as is normally said, a liability not accepted, etc. A claim made, liability not accepted. There are so many caveats which are added to a balance sheet. But where you have, without reservation, reflected amount due and owing to a party under a balance sheet, I don't think it would be appropriate to consider that this, being a mandatory filing, cannot be treated as acknowledgement of liability. So this, therefore, are the various aspects of the Limitation Act which are made applicable. It's a controversy which really started, and it is finally ended with this set of cases. I'll now move on to the next subject. Please go to the next slide, Shiva. This is in relation to Section 230 of the Companies Act. And here again, there is a little bit of an issue on how this is being followed by the NCLT and NCLA. What really happens is, if the resolution process fails and the company goes into liquidation, the liquidator, who could be the resolution professional or could be another person, has a right to move an application under the Companies Act under Section 230 for formulating a scheme for the consideration of the various stakeholders insofar as the company is concerned. This does not take place at the stage of resolution process, only at the stage of liquidation. Because stage one, if there's a resolution plan which is under consideration, people go with it. The resolution plan is considered. If the resolution plan fails, if there's no resolution plan, then you go into liquidation. Now, I'll read Section 230 of the Companies Act only to that limited extent, because it talks of a compromise arrangement being proposed between a company and its creditors, any class of them, between a company members and any class of them. The tribunal may, on the application of the company or any creditor, a member of the company, and this is what is relevant, or in the case of a company which is being wound up, of the liquidator appointed under this Act, in the Companies Act, or under the Insolvency and Bankruptcy Code 2016, order of meeting of creditors, etc., etc. So therefore, the whole scheme in 230 is that once you go into liquidation, it is open to the liquidator to formulate a scheme. If he or she finds that it is possible, even at that stage, to resolve the company, formulate a scheme of arrangement or compromise, as the case may be, with primarily it will be the creditors at that point of time, and subject to the consent of the various stakeholders, take it forward. What has happened is, in recent times, when appeals are filed against orders of liquidation, the NCLAT is passing an order directing the liquidator or recommending that the liquidator could explore the proposal of formulating a scheme under Section 230 of the Companies Act. So this is a scheme whereby there would be a compromise with the creditors, because at that point of time, the primarily creditors who have a stake in it. And one of the judgments which came up at this stage was SC Shetwin versus Amit Gupta. It's an order dated 29/1/2019. Of course, there are other orders to similar effect. The reason why I'm referring to this specific order is because of what followed from this order. Now, in this order, the NCLAT, while recommending that the liquidator could consider the option of a scheme under Section 230, also directed that the NCLT, while doing so, should follow the procedure under Section 230 of the Companies Act. Perfectly valid. I mean, nobody can question it because because actually the NCLT is wearing two hats. One is it's deciding matters under the IBC and ordering liquidation, or as the case may be, whatever it is, under the IBC. Where a scheme comes up in respect of the same company, it is then switching over to the Companies Act and considering the scheme purely in terms of the Companies Act. Here the IBC steps out because you find that apart from the fact that the liquidator IBC considers the scheme, there is no mention of any procedure under the IBC being followed insofar as the scheme is concerned. So therefore in SC Shekaran, what was held is please follow the procedures set out in Section 230 of the Companies Act. Perfectly understandable. However, what has happened is this has been followed by a second order in Y. Shivaram Prasad's case. This is an order dated 27/2/2019, barely a month after the SC Shekaran's order, wherein the NCLAT has stated this. Before approval of an arrangement or scheme, the adjudicating authority, that is the NCLT, should follow the same principle and should allow the liquidator to constitute the committee of creditors for his opinion to find out whether the arrangement is feasible or not, and having appropriate financial matrix. Of course, the NCLT given the further discussion disregard irrelevant objections. But what really follows from this is it requires the NCLT before approval of arrangement. We're not sure what is the stage of approval of arrangement. It says you must constitute the committee of creditors and find out whether the scheme is feasible or not. Now, this is where the crunch lies, because these committee of creditors are people who are involved at the stage of the resolution plan. They have the primary role to play, and when we go a little later into the law, we'll also look at the issues in relation to this plan. But in the resolution plan, they play a primary role. The primacy is given to them. Supreme Court has also held in SR that they have primacy. They will consider whether the resolution plan is feasible, whether it should be approved, rejected, or whatever else they want to do with it. So they are given the primary responsibility. But that jurisdiction ends with considering and approving or rejecting the resolution plan. Once it comes to the stage of liquidation, I have not seen any provision which talks of the committee of creditors again getting constituted to consider the scheme of arrangement, especially since this scheme is being proposed under Section 230 of the Companies Act. Now, to go back to this order, it says before approval of arrangement of a scheme. Now, what is the stage of approval of arrangement of a scheme? There are two stages in Section 230. The first stage is to convene a meeting. The second stage is sanction of a compromise or arrangement. According to me, neither of these two stages would the committee of creditors really have any role to play for this reason. In the first stage, you see what the NCLT is doing. It is convening a meeting of the creditors or class of creditors. If there are secured creditors, there will be a class. If there are unsecured creditors, there will be a class. If there are some other creditors, there will also be a class, etc., etc. So they're convening either a creditors meeting in totality or a class meeting of creditors to consider this very scheme. So the view of these creditors is going to be known in the meeting at which they attend, and they either sanction the scheme or reject the scheme. The requirement is 75% should sanction the scheme in order for it to be taken forward. It's in fact much more than a resolution plan, which is only 66% of the creditors. But be that as it may, now when it comes up for the first stage, all that the NCLT is doing is looking basically at the parameters of the scheme. You don't need to look at it with any kind of any grace scrutiny, because you're just making sure that the scheme is not an illegal scheme. It's not intended to thwart something else or delay the liquidation proceedings. It's a bona fide scheme. That's something which the NCLT could itself look at. And if it feels that, yes, a meeting should be convened, it's going to call for a meeting of the creditors. and the view of the creditors is going to be known at this meeting. So they're going to either approve the scheme or reject the scheme. Therefore, at this stage, to constitute a committee of creditors will really not serve any purpose, because anyway the views of the creditors are going to be known when they really consider the scheme at the meeting of the creditors. Now look at the second stage, at the stage of sanction. When it comes to sanction, the views of the creditors are already known. If they've approved the scheme, then the NCLT, of course, would still have to look at the legality of the scheme to make sure it's not a scheme that's intended to violate the law, and it's a bona fide and a scheme which could work. So at this stage, you also know that all the creditors have either approved it or disapproved it, in which case, and even if one class of creditors disapprove it, the scheme doesn't go through. So at that stage, again, the question of constituting a committee of creditors and their opinion is irrelevant, because they've already given their opinion. So therefore, this requirement of a liquidator constituting committee of creditors is really a matter which is probably outside the jurisdiction of the NCLT, because 230 doesn't provide for it. The committee of creditors are seized with the liquidation, because thereafter it's only liquidator who takes over. And in any event, the views of the creditors will be known definitely at the meeting. So therefore, this order again requires to be looked at a little closely to find out what really is the purpose of this. I'll move on to the next subject, which is the IBC. Please go to the next slide here. IBC and foreign awards. Now, this again is a fairly interesting subject, and I'm sure in the discussion process, Anirudh and others are going to have a lot to say on this, because I have held discussions with him on these aspects, and there's no real finality to it. What happens is this: if there is a foreign award, the IBC does not make a distinction between a domestic award and a foreign award. In the context of an operational debt, a amount which is due under an award which has become final, in the sense has not been challenged or has been challenged and rejected, is capable of being taken up with the NCLT. Of course, recently there is a judgment which seems to say something different, but I'm going on the basis of this foreign award. Now, the question is whether the provisions of sections 46, 47, and 48 of the Arbitration Conciliation Act would have to be complied with before proceedings under the IBC are commenced. And there is a judgment of the Bombay High Court which says that only when the enforcement process is undertaken would an award be treated as being final and binding. Because that's not in the context of the IBC, but nevertheless, there is one judgment. 46, 47, and 48 of the Arbitration Act require an award to be filed in the High Court. And only when it is filed and the conditions for enforcement under 48 are satisfied, the documents under 47 are set out, can the foreign award be said to be binding. So therefore, the question is whether these provisions would be applicable to IBC. Now, these provisions are specifically in relation to the enforcement of a foreign award. Now, under the IBC, what is happening is you're not enforcing a foreign award. Your award is being treated as a debt on the basis of which other proceedings are being commenced. So whether this principle would apply or not, or whether following the judgment of Uttam Singh Dugal's case, which says that an award which has become final, in that case not been made a rule of court, because under the 1940 Act, an award had to be made a rule of court. Assuming it's not made a rule of court, what happens to award? Is it final and binding or not? The Delhi High Court said that insofar as the controversy between the parties is concerned, this award is final and binding. And it's conclusive on the controversy and is not merely a proper award. I am not going further on this specific aspect because this specific subject is something which I've argued before the NCLT, and the NCLT has reserved orders on it. I'm not going to tell you what I argued or for which side I argued it, but I only open this up without giving you any conclusion on this because it's not fair on my part to conclude on this either way, since it's been argued and the matter is pending before the NCLT. So these are some of the aspects which relate to open issues which have gone back and forth on the thing. Now, I'll also get into some other subjects which are topical. They're not really controversial, they're topical. Just to take you through the, how much time do I have? I have another 15 minutes, I think. So in this 15 minutes, I'll try to take you through some of the other orders of the NCLT which are of some significance and what is their effect. One of the issues is in relation to the moratorium under section 14 of the IBC. Now, the question that arose was this. In section 14, it talks of a moratorium contains two limbs. It says A, it refers to proceedings, and it also says, it talks of institution, the moratorium prohibits. I'm only on the question of institution of proceedings. Institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of judgment, tribunal, order, tribunal, arbitration panel, other authority. So that's a moratorium which will be applicable insofar as pending proceedings are concerned. Now, there is a little bit of I think a word missing in code, but I don't think it's of much significance. It talks of institution of suits or continuation of pending suits or proceedings. Now, I would assume this has to be actually read as institution or continuation of only pending suits or proceedings, because otherwise it looks as if you can institute a proceeding, but you can't continue proceeding. If you were to read this literally, it looks as if what is prohibited is the institution of suits, not institution of proceedings, but continuation of suits and proceedings are prohibited. So I think the right way of reading this was the institution or continuation of pending suits or proceedings is where it should be read. The issue is words used against the corporate debtor. So the position that arose was, if there is a proceeding pending by the corporate debtor, would that also be stayed by this? Because it seemed illogical that you stop any proceeding against it, but you allow a proceeding to continue by it. Now, of course, the logic is quite clear that if a corporate debtor is to recover money from a third party, then obviously it should not be prevented from recovering that money. However, since if there's anything which impinges on the assets of the corporate debtor, that ought to be stopped, because it is on the basis of assets, liabilities, etc., disclosed in the information memorandum and other details, and a liquidation value arrived at, that a resolution plan is being formulated. So if therefore proceedings were to continue and the assets are going to be frittered away during the pendency of the resolution process, then any resolution plan which anybody submits would become redundant. But the issue still was whether it is by or against or only against. Now, the Delhi High Court in Power Grid Corporation vs. Jyoti Structures considered the word used in section 14(1)(a) is against the corporate debtor, whereas if the company went into liquidation, in terms of section 33, subsection 5 of the code, the words used are by or against the, section 33(5) of the code, the words used are no suit or legal proceeding shall be instituted by or against the corporate debtor. Now, therefore, when a liquidation order gets passed, no suit or other legal proceeding shall be instituted by or against, which means as a complete, to use a very current phrase, a lockdown insofar as litigation is concerned, insofar as proceedings are concerned. So, therefore, Delhi High Court is looking at the distinction between the wording used in 14(1)A and the wording used in 33(5) and said the first part of it is only insofar as proceeding against the corporate debtor is concerned. However, if it goes into liquidation, because at that point of time everything comes to a stop, all proceedings, no proceeding shall be instituted or by or against the corporate debtor. What happens to pending proceedings at that point of time? Not clear. Because if there's a pending proceeding, now the moratorium comes to an end with the resolution plan. Once it goes in liquidation, there's no moratorium except what is provided for in 33(5). That is, no suit or legal proceeding shall be instituted by or against the debtor except with the prior approval of the adjudicating authority, which is NCLT. Now, what happens to pending proceedings if the moratorium has been lifted? Can it continue or not? Not clear yet, except that there's a little bit of clarity as we go down this. Now, moratorium applicability, would it apply to other kinds of proceedings? Would it apply to pending criminal proceedings? Would it apply to Section 138 proceedings? Would it apply to any other proceedings? The uniform orders of the NCLT and NCLAT have said it will not. Because if there's a criminal prosecution or proceedings of 138 or proceedings of that nature, then those can proceed. 14 will not be a bar to it. Now, in the context of a counterclaim, one issue which arises is about a counterclaim. What happens to a counterclaim? A suit has been filed by a corporate debtor. A creditor has filed a counterclaim against it. So will the suit alone proceed and not the counterclaim? The Delhi High Court in S&P Industries has held that insofar as counterclaims are concerned, you can proceed with it because mere proceeding with the counterclaim does not impact the assets of the corporate debtor. Once the counterclaim is adjudicated and it is found, supposing counterclaim is rejected, nothing would follow. But if a counterclaim is allowed and a counterclaim is something over and above the amount of the suit, then on that situation, Section 14 could be triggered. Which brings us to 2-3 issues on a counterclaim. One is that let's assume a suit is rejected and a counterclaim allowed, perfectly understandable. Let's assume that a suit is decreed and a counterclaim is also decreed. Does it get set off, or the counterclaim at that point of time remains a dead letter and will not be adjudicated upon? The third thing is where both of them are partly allowed. So I would think that in the context of Section 14 and the law on it, that when a counterclaim is adjudicated, then to that extent, 14 would apply to that counterclaim. There can be no enforcement of that counterclaim against a company, and whereas the decreed portion would still be a portion which would constitute an asset of the company, because the person making the counterclaim would stand as an unsecured creditor of the company and would have to get whatever any other unsecured creditor would get under the resolution plan. Now, there are several other pronouncements of the NCLT, but for the present, I will not get into them. But what I will get into, and this, I think we are also a little short of time. So what I will get into is this issue in relation to the IBC and winding up petitions. Shiva, if you could go to the slide which says fresh applications under IBC and winding up petitions in the fourth. There's a slide to that effect. Just take that. Yeah, thank you. Now, here the issue that arises, and this has been decided by the Supreme Court in Porek India Limited, and which has been followed by the Madras High Court in Mason Healthcare Private Limited, was this. Now, there are winding up petitions against a company. There are likely to be innumerable winding up petitions against a company. When the IBC got enacted, what really happened was that proceedings were transferred when the NCLT got jurisdiction, rather, of, when the NCLT got jurisdiction of winding up proceedings under the Companies Act, in place of the court, what followed was a transfer of proceedings from the High Court to the NCLT. There are various judgments of what stage it can be transferred. You now have a transfer regulation itself which says which are the petitions which are to be transferred or not to be transferred. I'm not going down that route because I think that's now well settled. But what really happens thereafter, because you're in a situation where there are proceedings pending in the High Court, and there are proceedings which have been transferred and are pending before the NCLT. Now, at this point of time, the IBC has come into force. The IBC specifically bars any fresh proceeding being filed in a court. So let's assume that there is a creditor who needs to file a petition under the IBC. Now, the Limitation Act applies to it. There's no exclusion of the Limitation Act insofar as these proceedings are concerned. So, what is the creditor to do? This is an issue which arose in Forex and also in Boston Healthcare Limited, because at that point of time you had proceedings which were pending in the Madras High Court. While in Boston Healthcare the petition was admitted, liquidators appointed, thereafter a settlement was reached and both orders were revoked, which meant that petition alone was pending. So at that stage, what happened was a creditor, an operation creditor, filed an application under the IBC before the NCLT, in which case the resolution professional was appointed. So the issue which came up for the consideration of the High Court in an application under Section 446 was whether the creditor could have moved the NCLT when in fact there were petitions pending in the High Court. Now, 2-3 issues arose. What does a creditor do? Does it mean he can't file anywhere? He can't file it in the High Court because the jurisdiction is taken away, and the IBC specifically bars winding up proceedings being filed in any court other than the NCLT. So, therefore, the court had to consider the balance between the Companies Act and the proceedings in the High Court under Companies Act, as well as proceedings in IBC. In terms of Section 238, the IBC overrides any proceedings contrary to it. B, the creditor would have to file only before the NCLT. And C, he cannot file it in the High Court. The Supreme Court in Forex, which will be followed by the High Court, held that it is open to a creditor to move the NCLT and IBC, though many petitions may have been pending in the High Court. And if the resolution professional is appointed by the NCLT, then what follows would be the proceedings on IBC, approval, rejection of resolution plan, plus winding up, which will naturally follow. In fact, the Bombay High Court took the stand, tried to do a balance, saying that if the NCLT is inclined to admit it and the resolution plan fails, then you have to refer it back to the High Court, because the High Court will do the liquidation, it being a superior thing. But the Madras High Court, neither Supreme Court nor Madras High Court has accepted that reasoning. What they've said is, since IBC is a proceeding by itself which overrides everything else, since liquidation would follow the rejection of a resolution plan, it would thereafter be the NCLT room which would have jurisdiction. With this caveat, if meanwhile the liquidator has been appointed by the High Court in the pending winding up petition, then it is a High Court which will have jurisdiction over the winding up. The NCLT will not at that point of time have it. That is a balance which has been struck between these two proceedings. Before parting with this, I need to deal with one other judgment which which is the judgment in the embassy case. Because the issue that arose was, it's a judgment of the Supreme Court in embassy property developers, and there's also a similar judgment of the Bombay High Court, which brings in the issue of the applicability of Article 227 or 226, whether the High Court should entertain petitions under 227 specifically in relation to orders passed by the NCLT. Because if you look at the hierarchy of the IBC, it is the NCLT, it is the NCLAT, and thereafter the Supreme Court. And the code also bars any other court from taking or assuming jurisdiction over any of these proceedings. Now, here, this is where the Supreme Court has passed a very an order, far-reaching order, because what the Supreme Court says is this: they say that the jurisdiction of the NCLT is confined to proceedings under the IBC. You would have to act within the meaning of within the limit of the jurisdiction of the IBC. You can't overreach yourself and get into proceedings under other enactments, because that is not something which you are empowered to decide. There is a court, you are appointed as an adjudicating authority under that court, and your jurisdiction is confined to matters which arise under that court. Obviously, it's a very wide jurisdiction, it's an overriding jurisdiction, but nevertheless, it's a jurisdiction under that court. So there, what has happened is, this particular case in embassy property developers, the NCLT passed an order directing the authority to make an application of the Mines and Minerals Development Regulation Act, and there were other judgments in relation to Income Tax Act, all of which are orders passed by the NCLT. Now, those who question before the High Court on Article 227 saying this is a complete overreach of jurisdiction. This is not a jurisdiction vested in the NCLT at all. There are also matters arising under PMLA, the Prevention of Money Lending Act, PMLA, where the NCLT has said that assets seized under PMLA are subject to the proceedings and the IBC, therefore misuse those assets. And in all these cases, judges have entertained jurisdiction under Article 7 and set aside such orders, because it is not of exercising jurisdiction which is subject to the hierarchy of courts, but this is a case of assumption of jurisdiction which you did not have, and therefore it will be amenable to the jurisdiction of a high court in the article. It is subject to what let me stop now at this stage, and let's subject to what the organizers do. Let's open the floor to discussions and interaction amongst all the participants in today's meeting, so that let's try to find answers together to some of the concern us insofar as the IBC is concerned. Thank you. Please, if you can open it, we can start the discussion.
So thank you very much for the enlightening talk. You took us through a number of gray areas in the subject, and it's, in fact, absolutely fantastic lecture which we thoroughly enjoyed and benefited from. There are a number of questions that have been posed. So okay. Shiva will take you through each of those questions, and then I also have a couple of points that I would like to flag at the end of it.
Sure. And as far as the questions are concerned, we'll try to get answers, but if anybody else has an answer, please go ahead with it, because however, I mean, you're all practicing professionals in the IBC, so if there is something in opinion which either if you have, I'd also like to.
Yes, sir. So I'll take you through the questions, sir.
Okay.
The first question is, can High Court interfere in insolvency proceeding where the workmen dues are misappropriated by the company and not deposited with PF authorities, but RP failed to consider that aspect and submitted the resolution plan? The question is asked by Mr. Saravana Kumar.
Okay. This is a very, what do you call it, a vexing question, because if the question is this, whether the NCLT has jurisdiction under the IBC to decide this issue. If it did, then obviously you would have to follow the hierarchy of courts and take it all the way to NCLAT and the Supreme Court. However, since what arises for discussion here are the provisions of the Provident Fund Act, and the violation is therefore of the Provident Fund Act, I see no reason why the High Court should not exercise its jurisdiction under Article 227 in respect of the proceedings under the Provident Fund Act to punish the directors or whoever has misappropriated those funds. I don't see any lack of jurisdiction there, but if there's any other viewpoint, I'd like to hear it also.
Thank you. Thank you, sir. The next question is, IRP was appointed on 24th, 2018. The appointment of...
Sorry, I lost your voice, Shiva. Sorry, your voice is lost. I've lost your voice.
I think Shiva's logged off for some reason. Maybe.
Can you hear me now, sir?
Yeah, now I can hear you.
Yeah, the resolution plan is approved. Returns for financial year ending 19 has to be filed. Can the RP call upon the suspended board to confirm the accounts, or alternatively, can the suspended board refuse to sign, stating that their powers are suspended?
This is you see, at every seminar of chartered accountants which I have addressed in IBC, this is a very vexing question which has been raised. Because what really happens is that, I'll try to give you the answer, but what really happens is this. Now, in terms of section 17 of the IBC, once an RP has been appointed or IRP has been appointed, the powers of the board of directors is suspended. Now, one of the powers of the board of directors is to sign the accounts. Now, that also stands suspended by this. Now, therefore, can the RP call upon them to do it, or can the RP sign it himself? Now, this probably relates to a period prior to the RP or IRP assuming office. So, therefore, he is not in a position to certify the correctness or otherwise of the accounts. The second practical issue is this. The din of the erstwhile directors of what are recorded before the ROC. It will only, unless a filing is done under the din of one of the suspended directors, it will not be taken on record. Now, the suspended directors could say that I've been suspended, my powers are suspended, therefore I have no role to play in the signing of the accounts. It's a very vexing question. The only answer I could think of is that an appropriate application would have to be moved by the RP under section 60, subsection 5, if I remember right, of the IBC, and require the suitable directions be passed with regard to the signing of the accounts. Insofar as, but frankly, there is no straight answer so far, because it appears to go against the thing, because you're asking a suspended director to carry out a function which he should have done before he was suspended. But according to me, that could be the only way of approaching it. The second is, what do you do about the din? To follow up on this, whose din is to be given while filing the requisite form? Because unless a din is uploaded and the din is available with the ROC, the form will not be taken on record at all. So it will have to be the din of the suspended directors which has to go on record. So how do you match both these things? My only thing could be that since the NCLT has wide powers under section 60, move the NCLT, get suitable directions and proceed according to this.
Thank you, sir. The next question is by Mr. Chandramouli Prabhakar. In the lack of clarity regarding the prospectivity or retrospectivity of the March 2020 increase to the IBC threshold, that is rupees 1 crore, would all pending proceeding before the NCLT filed prior to such increase be affected?
I don't think so. I agree there's a lot of clarity in it. They should have been clearer so far as this is concerned, because you can't set at naught everything that has been filed before this. What happens to orders passed in so far as matters less than 1 crore, those orders all get set aside. So in my opinion, this could only be made prospectively applicable, because otherwise what happens is it sets at naught all pending proceedings which were legitimately filed under the relevant act. That act, unlike the Limitation Act, the act envisaged filing above 1 lakh, and it's been filed rightly under those provisions. Now, you can't, by a subsequent litigation, set at naught something that's been filed, because if that has been rejected and limitation has since expired, where do I go? So, according to me, this 1 crore should be applicable and possibly will be applicable only to pending proceeding. Only to prospective. That is, it's applicable only prospective.
Thank you, sir. The next question is, if prior to IBC proceeding, there is suit for rejection and recovery of ejection and recovery of unpaid rentals, what happens to the suit? Assuming the suit is decreed, how does one recover the outstanding rentals? It's a register. In the case, it is a registered sale deed, lease deed.
Yeah, I mean, I don't think there's a difference of registered or otherwise. The person required to recover the rent, I'm assuming that he has not filed proceedings under the IBC for recovery of it. If, therefore, claims are invited by the IRP, then he would have to make a claim, and he will be treated as an unsecured creditor. And whatever provision is contained in the resolution plan covering unsecured creditors will continue to would apply to him, assuming that this suit has been decreed prior to the commencement of these proceedings. Obviously, if it has not been decreed, the whole suit would have got stayed by virtue of the moratorium, and he would not have it decreed.
Thank you, sir. The next question is, to what extent, there are two questions in this, sir, by Mr. Sai Sudarshan. To what extent can the RP disclaim a contract in the light of Bhushan Steel judgment by NCLAT? And to what extent does the Section 20 Clause 1 affect that power? And there's a follow-up question. How is Y. Shivaraman Prasad affected by the introduction of the Stakeholders Committee?
No, there is let me answer the second question first. The Stakeholders Committee is not, Stakeholders Committee is to consider a sale of the assets. If you actually go into the rules and see why a Stakeholders Committee is being constituted, that committee is being constituted to consider the sale or affirm the sale of the assets of the corporate debtor. That's where the Stakeholders Committee has a role to play. However, in the context of Shivaram Prasad, what is happening is not a sale of the assets. It's a scheme of reconstruction or arrangement of the company, which may or may not involve the sale of its assets. And in any event, since a meeting is being called of the creditors in pursuance of that scheme, should there also be a committee of creditors overseeing it and deciding? Well, you see, possibly the committee of creditors have already rejected a resolution plan. Now, if they were to again say the scheme is not feasible, there is no provision for that in 230. And secondly, should the NCLT actually get their prior consent or approval before even convening a meeting, when in fact in that meeting you're going to get it? Bush and Steel, I'll look at it and answer. I don't have an answer straight away. I will look at it. I will circulate my answer once I've seen it. I don't want to answer off the cuff without going to the specific thing. Shiva, I'd only like you to share that, send a mail sharing that question. I'll look at it and I'll answer it.
Will do, sir. Thank you, sir. The next question is by Mr. Ashan Shanbag. The question is, in a case where the order of liquidation against the corporate debtor has been reserved by the NCLT, since no resolution applicant was successful in getting their plan approved, there is now a genuine buyer who wants to receive the company and keep it as going as a running concern. The buyer reaches out to the RP to find out the details as to how to proceed, who in return says that the application under Section 230 can be filed. However, when the buyer asks for the details, what amount is due? Due to which? Just a second, sir. There was another follow-up. The question was in two parts. I'm sorry, sir. I'll move on to the next question. Yeah. The question is, can an employee of the company file a proceeding under IBC for winding up as an operational creditor?
Yes, I think that's there in the code itself. Who is an operational creditor? I think if you go back to section 3 of the code, sorry, just give me a minute. Section 5, I think, sorry. He can. I'm just pulling out the provision which deals with this specific aspect. Sorry, just give me a moment.
No issues.
Yeah, it is section 521, which says operational debt means a claim in respect of the provisions of goods or services, including employment, or a debt in respect of payment of dues and any other. So in the light of that, you can probably move. An operational debt, an operational creditor is a person to whom an operational debt is owed. So that will be the.
Thank you, sir. So the next question is by Mr. Dhruv Gupta. If an IRP is appointed and he issues a check towards disbursement of certain immediate expenses and the check is dishonored, would an IRP be liable to proceed under Section 138 of the Negotiable Instruments Act?
I don't think so, because he is actually doing it on the basis of there is a protection being given to the IRP also in respect of actions which can be taken against him. But because basically it again depends on why the check bounces. Is it for want of funds? Is it? I understand if the IRP stops payment of a check, then he is actually doing something the same. But if it is because of want of funds for the company, I don't think you can hold the IRP personally liable under 138.
Thank you, sir.
But I will look at it again. I know there's a provision to that effect. Let me look at this. A protection is given to the IRP, but subject to this thing, I don't think he can be proceeded.
Thank you, sir. I'll move on to the next question. This is by one Ms. Pooja Damodaran. What is the effect of arbitration agreement when an IBC proceeding is initiated? Does it stand invalid or can parallel proceedings be conducted?
An arbitration agreement is valid. I mean, an arbitration agreement does not become invalid. But if you look at the judgment of, let me just pull that out. I'll just refer you back to that judgment because there's a specific this issue which came up. And you're talking about, I'm assuming you're talking about after the application is admitted and the moratorium sets in.
Yes, sir.
Because if there's no moratorium, obviously you can do it. There is a judgment of the Supreme Court in Alchemist Asset Reconstruction Company versus Hotel Gaudavan, where they've held that after the moratorium, arbitration proceedings cannot start or continue against a corporate debtor. Because there's a little bit of this thing, why it can't start is a little bit of a question because a start of arbitration proceedings is not directly affecting the assets, but I'm assuming it will fall within the scope of proceedings which are covered by section 14. One of the thing which says that you can't start arbitration proceedings or continue it because this is an alternative to a suit. If you can't institute a suit or continue a suit, you can't institute or come in or proceed with arbitration once the moratorium comes into effect.
Thank you, sir. The next question is by one Mr. Kalicharan. To what extent an attachment of corporate debtors' property under the PMLA is valid during the period of moratorium?
It looks as if the PMLA is outside the scope of it because this is the issue which arose of how far this, because what really happened is the NCLT, I think, passed an order saying that the attachment on the PMLA, I'll get you that judgment, is the attachment of PMLA is invalid. Those assets should fall into the general pool and be subject to it. I think the Supreme Court has said no. The PMLA is an independent enactment. They set aside that order of the NCLT or NCLAT as the case may be and said that PMLA being an independent enactment and this being in the nature of a criminal liability following the various judgments which say that moratorium will not stop criminal actions, this attachment of PMLA will continue.
Thank you, sir. So the next question is by Ms. Umay Parvati N. Do you feel that the judgment in
embassy? Sorry, I've lost your voice again. No, your voice is gone again, sir.
Shiva may have dropped off. Sir, I'll read out the question.
Yeah.
Do you feel that the judgment in embassy property developers has been overruled in effect by the latest amendment to IBC, inserting an explanation to section 14(1)(a) to clarify that a license, permit or similar right granted by the central or state government, etc., shall not be suspended or terminated?
Correct, but see, the question is, it's a very interesting question, but the question is, could the NCLT exercise jurisdiction over that enactment? To find out the validity of course, the license will not, see, this is in the context of saying that you can't stop any such action being happening. But let's assume that a license has to be renewed, or a license has to, or you violate the provision some other enactment. How far does the NCLT have jurisdiction to go into that provision and hold that that is invalid? Because one thing is to say that this license, etc., will not be suspended. The other thing is to say that I think I've gone out of this one. Yeah, the other thing is to say whether the NCLT could exercise jurisdiction under some other enactment to find out. The question would therefore be, which is the authority which could exercise jurisdiction? If the NCLT did so, would it be acting within its jurisdiction to decide a matter under some other enactment? So in my opinion, yes, it has been watered down a little bit. but I wouldn't say that that's been completely taken away at this point. So,
Thank you, sir.
Anirudh, I think you wanted to share a couple of things also. So I think at this stage, if you want to share it.
Yeah, maybe I think there are a few more questions there.
Oh, okay.
After that, and I can.
All right.
Yes, sir. So the next question is by one Mr. Abhay Siddhant. Whether a foreign award passed during the moratorium period will be treated to be against public policy or other provisions of Section 48 of the Arbitration Act.
A foreign award is passed overseas. How far is an arbitration conducted overseas subject to the provisions of the IBC? You see, while it says that no arbitration shall start or be proceeded with, how far can this jurisdiction be extended to cover a foreign arbitral tribunal? So therefore, the question is, I don't think it will be against contrary. It won't be contrary to public policy, according to me, if the tribunal went ahead and passed an award. However, if it does come up for enforcement, then no such proceeding can take place because by the time the moratorium is coming to force. That I think would be the correct position. Anirudh, if you have anything to say on this, please add to it. This is my thinking insofar as I'm concerned, because you really have no jurisdiction to stop a foreign arbitral tribunal from functioning.
Yes, sir. On this, we actually had there was a case where we have a ruling of a foreign arbitral tribunal. What had happened was that once the arbitration commenced abroad, the RP filed an application under Section 14 saying that the moratorium should apply. We opposed it on the ground that the moratorium would not apply since 232 of the code has not yet been notified, and hence the IBC does not have extraterritorial effect. At this point, the tribunal has accepted it and the arbitration is proceeding. But I don't think there's any.
It will be a dead letter because the award which you get will again have to. You can't enforce it. It will have to come back, and you'll have to file it as a claim before the RP, and RP will have to consider it or liquidate as a case.
Unless the only other possibility could be one, if the company has assets abroad, then we could say that since 232 has not yet been notified, it can be enforced against foreign assets. The second possibility would be if a new management takes over, then we'll have to analyze what is the effect of the judgment in SR, because where the Supreme Court has said all old and pending claims stand extinguished, would that apply to a claim made to a person who at the relevant point of time was not bound by the IBC? I think all of these will
consider. Now the second thing is this, following up on that, if let's assume that it proceeds with it. Now the resolution plan phase and the company goes into liquidation. What is prohibited is only the institution of fresh proceedings, suits and proceedings. So at that point of time, if they pass an award, after it goes into liquidation, can you say such an award is contrary to public policy because the bar under 14 has been taken away by the time the award can be passed? So that award would be perfectly valid. That's also another way of looking at it.
Yes, sir. Yes.
You can't start something new, but you can proceed against this.
Yes.
And by the same logic, if it goes into liquidation, can you start a fresh arbitration? Is another issue.
So, but if the code is not even applicable outside the country at this moment,
how will all these apply? That's a larger issue because the code is made applicable to Indian proceedings. So you can't overreach. For example, of course, you have one issue on the. There is one on cross-border insolvency. Just one judgment which I've seen, in which they've said that you can reach assets. For example, I think it was in Jet Airways. It was in Jet Airways case where they've said that the liquidator in Holland would also form part of the committee of creditors in India. They have recognized the fact that he also has a right to participate in this, though it was a debt outside the country, and the committee of creditors were being constituted. In the Jet Airways case, the Supreme Court has held that the liquidator in Holland has a right to be one of the members of the committee of creditors. That's the only judgment I've seen on cross-border insolvency.
So I think all of these are interesting issues that we'll have to.
A lot. I mean, we can discuss this for next 2 days. There are so many issues, but I focused on some which, according to me, have matters to be said.
Yes, sir.
Yeah. Thank you, sir. The next question is by Mr. Hitesh Singhvi. Time of filing of the petition and the circumstances after filing of the petition to be treated irrelevant. There's a question mark. For instance, in O&M petition, the shareholding is considered only at the date of filing of the petition, and subsequent change to the said shareholding is irrelevant.
Sorry, I haven't followed the question. In terms of section 232, I think, 242 of the Companies Act 2013, which follows 399 of the old Companies Act 1956, the status of shareholders at the stage of filing a petition for oppression and mismanagement was what was relevant. Supposing changes later, or somebody gives a consent and somebody withdraws a consent, it's irrelevant to maintain the petition, because maintainability of petition is decided on the date when it is filed. That logic will not be applicable to an IBC proceeding. When you file a proceeding before the IBC, the amount owed to you should be in excess of 1 lakh, which was there earlier, or 1 crore, which is now. Once that amount is due, that has to be due at the time of when you file the application in order to maintain it. If they come back and paid you something in between, and the amount due to you falls below 1 crore or 1 lakh as it then was, the question is whether you can still proceed with it, whether it should be still admitted or not. But then that payment is supposed to be made, I'm assuming, with the consent of the NCLT. This is what you're talking about, is a payment made between the filing and the admission of the application. So when it comes up for admission, if the amount due is shown to be less than 1 crore, I don't see how still an RP can be affected, merely because at some earlier point of time it was due.
Thank you, sir. So the one more question, that is, can an RP reject a person who has evinced interest to submit a resolution plan on a ground that he has not prepared information memorandum and has not published EOI even after 300 days of CRP?
No, but are you saying that a resolution plan is being submitted without the information memorandum or anything else?
On the ground, the question is, can an RP reject a person who has evinced interest to submit a resolution plan on a ground that he has not prepared information memorandum and has not published EOI?
See, the point is this: there is a time limit within which all of these have to be done. Information memorandum, resolution plan, etc. I mean, information memorandum, EOI, etc., etc. And the entire resolution process should be completed within 330 days, excluding whatever exclusions are available. And now, in terms of the recent notification, excluding the lockdown period also, within 330 days. If within 330 days nothing happens, what follows it goes into liquidation. Of course, if the RP has been so careless as to not even prepare it within the 300-day period, I think it calls for removal of that RP and the appointment of some other person. But you don't have to wait for 300 days, you have to wait for the period within which he must perform the various activities. And if he has not done it, I think it's up to the committee of creditors to ensure that they replace him with somebody else who does it.
Yes.
Now, on this, I'd also like to point out one aspect, because we've dealt with limitation, etc., and you're talking about time limit. There is a Supreme Court judgment, all of you would have seen it, which extends the lockdown period for the purpose of filing of proceedings. Now, my feeling is that order will also apply to filing of proceedings under the IBC. This period of lockdown will be excluded from computation of limitation for the filing of proceedings under the IBC also. Yeah.
Thank you, sir. So, as you are aware that we are also live on Facebook, There is one question from Facebook, that is, when an order passed by statutory authority attained finality due to non-filing of appeal, can the same be interfered or rejected by the RP or liquidator?
I have, in what context? I mean, I'm not able to understand what context the question is coming. There is an order passed by a statutory authority.
Yes, that has attained finality due to non-filing of appeal.
Okay.
Now, can the same be interfered or rejected by the RP or the liquidator?
I'm assuming there are substantial reasons for doing it. He can't do it at the whim. See, if he finds that the statutory authority acted without perusing the records, without jurisdiction, etc., etc., I'm assuming the RP can look at it because he's ultimately finding out what is the amount due to the various creditors. But he has to act with substantive, he can't just do it at a whim. He will have to look at the order, he will have to look at the circumstances, but I don't think his jurisdiction is circumscribed merely because the statutory authority has passed an order.
Yes. So there is one last question, subject to your convenience.
Okay.
Okay, so can an RP reject a person who has the same question, sir? Sorry, sir, it's just a repetition, sir.
No problem. Okay.
Sir, subject to, if it's all right, I have a couple of points I could just place for your consideration, if you could.
Yeah, go ahead. Something to share.
So the first is, you mentioned the Delhi High Court judgment, which said that when there's a claim and there's a counterclaim, suit and cross suit, then it can continue, but you can't go and execute any decree. What about a scenario where there is a suit, there is a cross suit, the two continues, the two continue, the two are pending, and a new management takes over? In such a scenario, would the judgment in SR apply? Because if you're going to say all pending claims stand extinguished, and this is treated as a pending claim, then to say that the suit should can continue would really be of no effect.
No, but can you see? I agree. When you talk about pending claim, this is a pending suit.
Yeah.
Can you therefore go and what happens? The suit gets dismissed, is it? Because,
ultimately, let's assume that the suit is decreed against the corporate debtor.
Yeah.
So but the suit gets decreed much after the new management takes over.
Okay.
So what is the effect of the judgment of SR?
Only this, because I feel that this will be a new claim, which is a claim which is not already made, or a pending claim, or whatever it is. But if you file a suit, and the whole purpose is that for a new management, they should have some finality about it. You can't keep introducing new claims as we go along, because then your resolution plan becomes a complete non-starter, because there are new claims coming, new things coming. There's no finality to it. But if you're already aware that there is a suit and there is, let's say, a contingent liability in the company, according to me, I don't think that will get completely knocked out merely because a new management is taken over. In fact, there is an order of the NCLAT. How far it continues to be valid in the light after SR is a moot question. It says that if supposing a claim has been rejected by the RP, or a claim is not made at the relevant point of time, nothing prevents you from going under section 60, subsection 6, and making a claim even in the liquidation or whatever it is. So you can always raise it.
Yeah. So this argument was made in SR as well. Mm-hmm. And I think Supreme Court considered 66 to say that you can't raise a new claim against the new management, and that all pending claims also stand extinguished. Mm-hmm. But I think the issue that will have to be analyzed is whether or not
a pending suit will get rejected by it. And if you talk of a pending claim, I mean a claim, that is, you're talking about a claim which has not been accepted by the RP. Is what
yes, or not made before the RP.
Or not made. So that's not a pending claim. See, if you don't make a claim before the RP, then because there has to be a plan which considers all of it. But if you filed a suit or you have made a claim and the RP has rejected it, and you have not appealed, it becomes final. What happens is another question. Okay, go ahead.
Yes, sir. That's also, that was the only question. The other is in relation to, or okay, there's actually one more, if you don't mind, I will put that as well. See, what about a scenario where the provision, there's a provision in the resolution plan which says that the claims against the guarantor will stand extinguished. There's a passage in SR where the opposite is considered, where there's a provision which says that the claims against the guarantor will continue, and that the Supreme Court said is valid. But what about a provision which says that the claim against the guarantor stand extinguished? Can it be said that this is outside, that you can't extinguish rights vis-a-vis third parties by way of a resolution plan?
No, but if Committee of Creditors, ultimately they're talking about the Committee of Creditors accepting it, right? Because SR says that the Committee of Creditors has primacy to accept or reject a plan. And unless you find something terribly irrational about it, the NCLT itself cannot interfere with it. Now, if the Committee of Creditors has considered this and is still accepting this position, because the guarantor will be a guarantor insofar as the financial creditors are concerned. The financial creditors vote and decide by a majority that they will not proceed against the corporate guarantor. Can you say that this is wholly irrational? Because nobody else has you see, I understand if you say something which affects the operational creditors who have no voting right at the COC or somebody else, then you can say that you have deprived me of a recourse which I otherwise had. But in the absence of that, I don't see how SR will go against this.
No, what if it's a minority? If it's a minority financial creditor, say the 5% vote share, who has raised the objection, who has been outvoted in the COC?
Yeah, but that's the thing, no? The 66% is binding on all creditors. If you look at it, resolution plan approved by 66 is binding on all creditors.
Yes, sir.
Of the company.
That actually arisen in a case, but ultimately the NCLT did not decide. Though there it was in the context of a 230 scheme after the liquidator came to be appointed. So there the NCLT knocked it off on the basis that the objection was by a 5% financial creditor and they didn't meet the requirements of 234, and hence knocked it off on maintainability of the objection itself. But yes, sir, I think
I am getting a message from Vishnu Ramu that there's a judgment of Justice Satish Kumar on the same aspect, and he has dealt with SR case. I'll certainly look at it. Thank you, Vishnu. And of course, that's the. I think that's about. So if there's nothing further, I'll sign off at this point of time. Thank you all very much.
Thank you so much. It's been an absolutely enlightening session for all of us.
Thank you so much, sir.
Thank you.